In the event of liquidation and you have an overdrawn director's loan account, would you lose your house? One would hope not, but the answer to that question is one that nobody can actually give you a definitive answer. It entirely depends on the facts of the case. An overdrawn director's loan account is an asset of the company, and the liquidator has an absolute duty to recover it and to realise it for the benefit of creditors. That cannot be seen or otherwise and actually do nothing about it. There has to be an attempt made to realise it. It is as simple as that. Now, if the amount in question is substantial, then if the company goes into liquidation, you may find yourself being called to repay, obviously, a substantial sum of money. And your ability to pay it is going to be conditioned by your assets. So if you have a substantial proportion of your wealth locked up as equity in a property, then that is going to be a factor in determining whether or not you're going to be able to keep that property, or whether or not it's going to have to be sold to contribute or to repay the overdrawn director's loan account. On the whole, it would not be the norm by any stretch of it. It would be the exception for somebody to lose their home because of an overdrawn director's loan account. But that doesn't mean that it never happens. One would hope it doesn't happen, perhaps. But of course, it will depend. Obviously, if you've got other assets that are not tied up in equity in your property, for example, then they can be sold conceivably to repay the overdrawn director's loan account. But what cannot happen is, before you go into liquidation, for it to be determined, there is other factors that will determine whether your home is at risk. One factor might be the extent of the overdrawn director's loan account and the extent to which it's clear as to the amount that you owe, because there can be disputes and there can be accounting issues that arise that can potentially change the extent of the amount that you owe in respect of an overdrawn director's loan account. And that will potentially depend on your accounting systems in respect of the company before it went into liquidation. It will also depend on things like, for example, the liquidator's interpretation of how that overdrawn director's loan account has been compiled and the transactions that effectively break down and make up the overdrawn director's loan account. And this can lead to things like disputes over what amount a director actually owes. And the issue there is, if there is in fact a genuine dispute as to what a director owes, then you could end up in a situation where the liquidator, for example, envisages from the company's records that a director owes far more money in respect of an overdrawn director's loan account than they actually owe. And this can, in an extreme sort of case, lead to adversarial proceedings where the liquidator brings proceedings against the director to attempt to recover the overdrawn director's loan account. And of course, it's not a foregone conclusion that the liquidator will necessarily win those proceedings. It's possible, and there's no reason to think about it one way or the other. It's going to depend on the facts of the case, that the director may be able to successfully defend those proceedings. And that will also conceivably impact on whether a director were to lose their home. And obviously, if the director succeeds in defending the proceedings, then any legal costs they incur potentially would be payable by the liquidator or by the company. So it's not a straightforward question that somebody can simply say yes or no. Hopefully it won't happen, and in most cases I think it's fair to say it doesn't happen, and by some considerable margin. But what is not untypical is that an accommodation and a commercial settlement is ultimately the end conclusion, and that will essentially dispose of the matter. Questions, queries, concerns, give us a shout. We know insolvency inside out.